everybody. This is Advocate Lucinda, your empowerment lawyer. You know, I get messages from prosecutorials who allege that the state prosecutor violated their constitutional right during the criminal proceedings. And they ask me, well, can I sue the state prosecutor? Well, there's always going to be the question of absolute immunity. On its face, the state prosecutor has absolute immunity. But that absolute immunity is not unbreakable. And that's what we're going to talk about today. When a state prosecutor violates an individual's constitutional rights, he or she can be sued, because the truth is the prosecutor's job is to secure justice on behalf of the state, the victim, and guess what? Even the defendant. For example, if the prosecutor, during his or her advocating for the state, and they obtain information that tends to show that the defendant is not guilty of the offense he or she has been charged with, then the state prosecutor has a duty to not continue the prosecution against this individual. Okay? So let's get started. A state prosecutor possesses absolute immunity from civil liability for their core prosecutorial duties. And that was established in Embler versus Pacman 424 United States case 409 1976 case. In Pacman, the Supreme Court clarified that prosecutors do not receive absolute immunity for tasks that fall outside of their quasi-judicial advocacy role. They are generally only eligible for qualified immunity for these actions. Prosecutors lose absolute immunity and can be sued only when acting in an administrative or investigative capacity rather than as advocates for the state. And this comes from Buckley versus Fitzsimmons 509 US 259, and that's a 1993 case. In Buckley versus Fitzsimmons, the United States Supreme Court ruled that prosecutors are not entitled to absolute immunity for their actions during the preliminary investigative phase of a case or for making defamatory statements at a press conference, and are instead only protected by qualified immunity. And what is qualified immunity? If a prosecutor performs investigative or administrative duties that are not related to an advocate's preparation for a judicial proceeding, they forfeit absolute immunity and are only eligible for qualified immunity, also cited in Buckley versus Fitzsimmons. However, let's survive a lawsuit under qualified immunity. The plaintiff must prove that the prosecutor violated a clearly established statutory or constitutional right of which a reasonable person would have known. Stated another way, the prosecutor or reasonable official must have known that the conduct was unlawful. And another thing I like to add that with regards to the standard, Harlow versus Fitzgerald eliminated the subjective good faith inquiry with the objective legal standard. So let's look at some instances when the prosecutor loses absolute immunity for administrative and investigative acts. Administrative acts. Advising the police. Evidence handling, such as functioning as a custodian of evidence or responding to records requests. Workplace personnel decisions, making decisions such as firing or managing staff and office personnel. Making press releases or public statements regarding a case. Now, obviously, this list is not exhaustive. So you want to be certain to look at the rules in the jurisdiction in which your matter is pending and do your research regarding what the courts allow to show a case of prosecutorial misconduct as it relates to administrative actions or activities. And investigative acts. When performing police investigative functions, including directing police searches, evidence gathering, providing legal advice to police during an active investigation, questioning or directing police at a crime scene, searching for clues, visiting the crime scene to search for evidence. Again, this list is not exhaustive. You want to be sure to look at the rules in the jurisdiction in which the matter is pending. Determine which acts are considered investigative. So the defendant can't just make accusations against the prosecutor. The defendant has to have some evidence. So how do you know what the prosecutor's conduct was that led to the alleged prosecutorial misconduct? Well, let's look at some things that the defendant can do to uncover this conduct. Under Brady versus Maryland, 373 U.S. 83, 1963 case, it was established that the prosecution must hand over any exculpatory evidence. This includes evidence that could impeach the credibility of the prosecutor's witnesses or reveal investigator misconduct. And let's recap. What is exculpatory evidence? It's information that tends to clear a defendant of guilt in a criminal case. In Giglio versus United States, 405 U.S. 150, 1972 case, the defense can demand information regarding deals, leniency, agreements, or payments made to witnesses by the prosecutor or the police. Then there's general discovery. State laws require the prosecution to provide police report, audio, video recordings, email logs, and internal notes related to the investigation. And again, you want to always look at the rules in the jurisdiction in which the matter is pending to determine what's required to meet the standard of proof for that jurisdiction. Subpoenas. If the defendant suspects the prosecutor acted outside their official advocacy role, such as fabricating evidence or interviewing witnesses inappropriately. And in the subpoena, the defendant is moving to uncover evidence showing that the prosecutor performed administrative or investigative tasks. Subpoena duces tecum. The defense can issue legal orders for third-party records such as police department logs, phone records, or internal emails. Public records requests such as the FOIA, Freedom of Information Act, publicly available disciplinary histories, that's a good one, or complaints, another good one, filed against specific prosecutors or detectives. Depositions. In states that allow criminal depositions, the defense can question investigators and witnesses under oath about the prosecutor's direct involvement in the investigation. And really, generally, courts will deny a defendant's request to take the prosecutor's deposition. And that's because criminal depositions are strictly limited to preserving evidence in exceptional circumstances, okay? So we're not saying that a defendant could not score the prosecutor's deposition. We're saying it would be very difficult. Evidentiary hearings. If the defense finds initial signs of misconduct, they can file a motion alleging a constitutional violation, such as a Brady violation or vindictive prosecution. The judge may grant an evidentiary hearing. During the hearing, the defense can call detectives, witnesses, and sometimes the prosecutor to testify under oath about their conduct. Remember, it's critical to look to the jurisdictional law in which the matter is pending. Now, having said that, if the defendant is filing a lawsuit against the prosecutor under, for example, 42 USC 1983, which is a federal statute, then the defendant certainly want to and look to and study the federal laws and rules. You know, I trust that this information was helpful to you. I hope that it gives you hope and a fighting chance to get justice. I'm Advocate Lucinda, your empowerment lawyer, and we will see you next time. Take care.